Presidential polls. Senior lawyers back Agbakoba on 25% requirement from FCT. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel. To get notified when we post hot juicy news updates, please click on the notification bell. Prominent lawyers have agreed with the former president of the Nigerian Bar Association (NBA), Chief Olisa Agbakoba San, on the issue of obtaining 25% in the Federal Capital Territory (FCT) as a requirement to win the presidential election, as provided in Section 134, 1B and 2 of the 1999 Constitution. Speaking on a live television program in Lagos, Agbakoba listed the two issues as reasons why the declaration Bola Tinubu as the winner of the February 25th presidential election may have a problem. He listed Section 1342 of the Nigerian Constitution, which provides a condition to be met before one is declared a winner of the presidential election, and Section 35 of the Electoral Act 2022 as amended, which forbids candidates from contesting two positions in an election. He explained that the two positions are very clear and unambiguous and do not require lengthy time argument for the tribunal to decide cases brought before them. 134 verse 2 is applied literally because the rule of interpretation says if you read something and it is so clear to you, then you don't need to interpret it. The thing says you must win a quarter of the votes in 2/3 of 36 states and the FCT. And then what do you want to say? The answer is obvious. When pressed by the presenter to break it down, he said, I've just broken it down. I've broken it down. You want to put word in my mouth, which I will not accept. It is so simple. You get a quarter of the votes in 24 states, then that's what the law says, which is 24. So that is one part of it. It goes on to say and what does that mean? And the FCT. So as far as I'm concerned, you must also win 25% in the FCT. But that is not for me to say because I'll be prejudging what is before the tribunal. So we think that the tribunal can answer this question quite easily in 1 hour. That is my point. Quite easily. It is not a difficult question to resolve, he said. Agbakoba had before the general election written to INEC to clarify his position on the true interpretation of a section. Aligning himself with the position expressed by Agbakoba, a constitutional lawyer, Ahmad Nzelu, described the issue as a time bomb. One major concern, which is a time bomb, is Section 134 of the 1999 Constitution, which described the requirement to be met by a presidential candidate to become the president of Nigeria. You can see that this section of the law is explicit enough so as to whether the 2/3 votes of a candidate must secure and maintained in the law would include or exclude the Federal Capital Territory FCT Abuja. For instance, to be the declared winner of the presidential election, a candidate must win a quarter of votes in 24 states, which makes up to 2/3, as well as the FCT or without the FCT. Does it mean that the Federal Capital Territory Abuja is incorporated in the 24 states? Or does it mean that the presidential candidate must also score not less than 1/4 of the votes cast at the election at the Federal Capital Territory Abuja? Can a candidate that scored not less than 1/4 of the votes cast at the election in 36 states of the Federation but fails to score 1/4 of the votes cast at the election at the Federal Capital Territory be duly elected as the President of Nigeria? This is a serious matter and it's a time bomb because somebody can win another state but may not win the FCT. The issue needs to be cleared by INEC, he declared. Lending his voice, Professor of Law and Human Rights activist Prof. Michael Zekome said there is no doubt that the provisions of Section 1342B of the Constitution is rooted in mathematics. It requires that a winning presidential candidate shall have not less than 1/4 of the votes at the election in each of at least 2/3 of all the states and the Federation and the Federal Capital Territory Abuja. Emphasis supplied. As lawyers, we should not always shy away from embarking on this mathematical pathway and to resolve the steaming controversy. Yes, mathematics is part of his lawyer's job in resolving disputes, and Nigerian courts are not strangers to mathematical judgment. After all, the 1979 presidential election involving Shagari and Awolowo was wholly litigated, won and lost on the basis of Supreme Court's mathematical interpretation of what amounted then to 2/3 of the then 19 states of the Federation. The Supreme Court is delivering judgment in favor of Shagari ruled that the requirement of votes to win the presidential election was 25% in 12 states and no more. It cautiously avoided the attended fractionalization of Kano State so as to avoid absurdity in interpretation. It is my considered opinion that the scope of the Constitution of the FCT Abuja as a state only applies to the enjoyment and vesting of executive, legislative, and judicial powers by relevant bodies in the FCT. It does not apply to all matters, extents, and for all purposes. Further, an interpretation that Section 299 of the Constitution applies for all purposes is too narrow. It is not holistic or inclusive. It will render many other parts of the Constitution redundant, futile, unproductive, meaningless, and therefore unnecessary. Certainly, such could not have been the intention of the legislature or lawmakers. Section 134 of the Constitution must therefore be interpreted to mean for a candidate to win the presidential election, such a candidate must obtain 25% of the vote cast in 2/3 of all the states in the Federation, 24 states, and further in the FCT Abuja. This is a compulsory requirement for a valid return as president. It seems to me that INEC is not properly legally guided when it declared a president-elect. Okay, let be small thing. This particular section 134 of the Constitution, they bring plenty yawa. If we do not go to school, even if you are not lawyers, on presidential election matter, the 1999 Constitution of the Federal Republic of Nigeria as amended never gave any special status to FCT, and the FCT mentioned the same as mentioned in every other matter affecting 36 states and the FCT. Mr. Agbakoba, are you in the 1999 Constitutional Conference? Are you a judge in the role of a judicial officer in the interpretation of the law? Let them do their job. Your opinion can never count. All right. Oman, okay, it is not 1/4 of a state votes cast in 25 states. It is 1/4 of a vote cast in 24 states, and then Abuja is specifically mentioned. To gain admission into any tertiary institution in Nigeria, a candidate is required to have passed 5 subjects at O level with credit grade, and these must include English and Math. If a candidate has 10 credit level without English and Math, he does not qualify for admission. So it is not so much about the number of subjects passed as the specified type. Many people don't turn interpreters of the law. This is making many people lawyers. No wahala. If the lawyers are confusing the public like this, what can we expect from a trial court? Most of them are selfish, looking for food, money at all times. Let us wait for the decision of a court. The APC supporters seem not to be educated. I must say this, and is an article that pluralizes different things. Nigeria and Nigeria means one country, while Nigeria and Togo means 2 countries, as well as 24 states, and FCT means 25 locations. Grammatically, and goes in between 2 or more different things in a statement. Mind you, sometimes the courts may frequently pass judgment. So if then the Supreme Court did interpreted that FCT is a state, then by now we should have 37 states and not 36. Okay, well, let us allow the court to decide. All right, on this note, we've come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.